Today's legal issue is, do I have to serve my spouse, or do I have to serve the other parent of my child when I start a case? This is an important topic to talk about because there's a couple different options, and there's a couple different pros and cons that come with each way to start a case. So in whatever kind of case you're doing, the way you start it is you file a petition. A petition is an initial document that you file with the court, and after filing that document, you get assigned a case number and you get assigned a judge. Once you have the case number and the judge, you as the petitioner are officially in the case. The court has jurisdiction over you because you voluntarily given the court jurisdiction over you by filing the case. Now, the court does not have jurisdiction over the respondent in the case, which is your spouse or the other parent. So the next step is to get jurisdiction over your spouse or the respondent, the other parent as it could be. The way you do that is either by requesting that your spouse or the respondent, as we'll call them, voluntarily files an appearance in the case. And you could do this by just asking them to do it. Your attorney could send them a letter asking them to do it, those are basically the two options. It's just a request. Can you please voluntarily submit yourself to the jurisdiction of the court? Can you please file an appearance? There is a fee to file an appearance, which is $237 in Cook County, and it's more or less that amount in the different counties of Illinois. The next option that you have, and we'll talk about these from most amicable to most aggressive. The next option that you have is to send your spouse a letter with an official form called an acknowledgement of receipt of summons. And by sending this form to the other side, you're asking them to acknowledge that they receive the summons, and in that way they won't have to be served. So if they return the acknowledgement signed, you can file with that with the court, and then you don't have to serve them by the sheriff. Now, the next option and the last option is serving them with the sheriff. Or actually, this option is, there's two different ways to do it. You can either serve them through the sheriff, or you can serve them through a private investigator, somebody you hire. Technically, it could be anybody that is not a party to the case that can serve them. The advantage of serving them with a private investigator is if there's any issue over service, then you can show the court that you've hired someone who's licensed to do this, that has a history of doing this, so that when they file their proof that they've served them, the court won't question it as closely. Say if your cousin or a family member served them, then the court's going to look at it a lot closer. So when the sheriff serves them, or a private investigator as it may be, they actually take the petition and they take the summons and they go to their house or go to their place of work, knock on the door, and when they open it, if the respondent answers, or if anybody who lives at the house answers, who's over the age of 13, the sheriff can serve that person. And once they've been served, the court has jurisdiction over the respondent. A lot of people don't like to go directly to service by the sheriff, and understandably, it is an aggressive move. It comes off as unnecessary to a lot of people. In my experience, it's necessary if you want to move a case along quickly or quicker. If there's other circumstances where you're concerned that the other side might leave the jurisdiction, you might want to go straight to service by the sheriff. Otherwise, it can't hurt to ask the other side to voluntarily file an appearance in the case, or to voluntarily waive service of summons and acknowledge that they've received the petition, and that way they won't have to be served by the sheriff. So those are the three different ways to get jurisdiction over the other side. Once you have jurisdiction over the other side, then you can start filing motions, requesting discovery, and doing whatever else you need to do to wrap up the case or move the case forward.